Peerally Law Show, where all your views matter.
Every Thursday, 10 to 11 a.m. only on Radio Zindagi, Jieja.
आज मेरे पास बिल्डिंग है, प्रॉपर्टी है, बैंक बैलेंस है, यहाँ तक कि स्मार्टफोन भी है। तुम्हारे पास क्या है?
भाई मेरे पास रेडियो जिंदगी है।
Radio Zindagi.
Thank you.
The views, opinions, and statements expressed in the following program reflect the views of the program contributors and do not necessarily reflect views of CAB Broadcasting LLC and its management or its sponsors.
Where all your views matter.
Hello everybody. Assalamualaikum, Sastakar, Namaskar to all the listeners. I hope you can hear me well. This is Attorney Shah Peerally and today is May 30th, 2019. It's the last show of this month and we're going to talk about few issues, but of course we will be opening the line in a few minutes. 510-657-1170. 510-657-1170, and I thank Michael for being on the show with me today. Thank you, Michael. And we will be taking callers, like I say, in a few minutes. And anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So, ladies and gentlemen, we're going to talk about a few things. For one, we saw a bunch of articles going on right now, basically, on the process of taking away the H4 EAD. But it's pretty much the same, whatever we were expecting, but it's moving kind of forward. But as we have said before, I don't think it's going to happen overnight because there are a lot of people getting ready to sue, etc., etc. But having said that, we need to expect some kind of things happening in the next 30 days. For those who have an H4 EAD, or planning to file one, we don't know really how things are going to work out, but what we are thinking, again, is, this is my guess, they will allow people who have it to maintain it until the date is expired, and they won't allow a renewal. This is how we're going to see things unfolding, probably same thing we've been saying, but it seems the articles are kind of going on the same ground that we've been saying, but again, until we see what happens on the OMB and next probably the OMB, they're going to basically go through it, and then the battle is going to start, and based on that battle we're hoping that we will be able to carry on with the H4 EAD for the next couple of years. That's our hope, but let's wait and see. So I just wanted to give that update. And also another thing we are seeing a lot of people calling us about is the 221Gs coming back, making its ugly face back, I should call it, and a lot of people traveling abroad, even for small visas, like, not small, but visas like H4, which usually don't have any problems. We are seeing people getting stuck. I have few cases where people get stuck for some time there, but it's it's still minimal compared to H1B cases and other cases. So 221G is the administrative processing, and it's 221G section of the Immigration Nationality Act. Basically, what it does, it kind of blocks your case for a while. There are kind of three of them. I've categorized it into three kinds of 221Gs. One, we have the situation of 221Gs basically based on, they will just keep taking a couple of weeks to do a quick background check and they release the case. Another one where the case gets stuck for months and even years sometimes. And the third one, of course, is a denial. And the case is sent back. If the case is processed by USCIS, they send it back to USCIS to re-adjudicate. And then USCIS, if they think they have not made a mistake, they return it back with an approval or a denial. So all those things are happening, but it's been happening, by the way. 221G is something very, very old. It's been going on for years. But once in a while, you see it coming back like really strong, and then what do you do next? One of the things that we have seen as an option when you have that is actually to go ahead and file what we call file a case basically based on refiling, for example, refiling an H-1B or refiling the entire case and see if it works. And sometimes it goes faster, but right now those solutions might not really be viable. So, Michael, let me know if we have any callers. The number to the studio today, 510-657-1170. You can call for any questions on immigration. It doesn't have to be on the topics we're talking about, so feel free. You can call on parents' petitions, asylum, deportation, you name it, H-1B, I-140s, labor certification, wherever I can kind of guide you as much as I can, I'll be glad to do that. Remember, whatever I give you as information here is purely educational, so it's not really a legal advice, so you have to be careful because sometimes when I speak to you, for one, I don't hear everything and I might miss stuff because I'm really doing this quick. And in this case, if the case is too complicated, it's good to call our office, 510-742-5887. 510-742-5887. And also, if you need any help on immigration, of course, feel free to call the same number, 510-742-5887. And the website to check, attorneyonair.com, attorneyonair.com, or you can actually check the PeerallyLaw.com. It's the same website. So it's today, like I said, it's May 30th. So we are live. You're free. You can call today if you want. If you have any questions, feel free to reach out to us. 510-657-1170. 510-657-1170. And we are, of course, talking about 221G, and a lot of people are getting stuck there. So the biggest question I get, should I travel and get a stamping? Is it a good idea? Well, it is an open-ended question, by the way, because it depends on many, many factors before you make this decision. If you know your case has been a hard case to win, you already have a lot of issues, especially if you're working, for example, for a consulting company, etc. Traveling abroad to get a stamping can be dangerous because once you go outside, then they reconsider the case from A to Z, and if anything is kind of not to their satisfaction, they might just not give you the stamp on the passport, and you get stuck outside. Having said that, most people come back. The few cases that you see not coming back, of course, you hear them a lot because they are the ones who are really getting in trouble. So we have some callers. Let me take the callers and then we'll continue on that. Shah Peerally, you're live in air. Hello.
Hi. Good morning. Actually, I have a question. I'm an Indian citizen and wanted to apply for U.S. citizenship. My wife wanted to change her surname to my surname while applying for U.S. citizenship. I came to know that if we after getting the citizenship and name changed, when we'll apply for Indian OCI, then they will ask for some proof of name change. And then there they want some court order or something like that. So in Bay Area, typically the citizenship is not proceeded in court before a judge. So how will we go about it? I wanted to know.
Well, that's a good question. Unfortunately, I cannot answer for the OCI because this is Indian law and I'm not licensed there. But all I can say in the U.S. for when you're married, you change your name, there's no need to go to the court. Unless you want to change your name for something completely different, then you need a court order. That makes things easier. But you can always try to use a court order if that will help with the OCI, but I cannot really guarantee that the court will allow you to do that. But you can go to the court and say you want to do it officially just in case for your OCI, and I'm pretty sure the court will understand. And try to do that. It might work, but that's another issue with the state court. And you need to go and check with the court clerk if they can help you on that. or talk to an attorney who handles state cases when it comes to name change, etc. But as for the OCI, unfortunately, I don't have an answer. Maybe one of our callers can call if someone is familiar with that issue and tell us a little bit more about it. But again, like I said, I'm not licensed in Indian law, so I'm not even allowed to give you an advice on that.
Actually, it's not, Mr. Peerally, it's not most of Indian law. It's just that they wanted some proof of name change. So
okay.
Yeah,
but if a wife takes the name of the husband, that's something very common in every common law countries. They don't accept that.
Okay.
Hello.
Okay.
Because whenever you're getting married, most of the time in common law countries like England, Canada, and things like that, they allow you, and America follows the same. They allow you to take your husband's name, right? Or you keep your own name, and that doesn't require any kind of change really to anything, except maybe you go to the Social Security office. Try to do that. Why don't you go? Because you will have to update the Social Security. Once you do that, then get the Social Security, a letter from Social Security or the card, and show them that. I hope they will accept that.
Okay. Got it, yeah.
But again, I don't know the exact answer. I'm sorry for that. Okay, but I'm going to research and see if I can give more details on that next week.
Yeah, I feel that Bay Area people, most of the people might be having problems. They want to go with this route. And you know the Indian embassies and consulate, they are like very strict about what they want. So
yeah. Well, on the US side, you don't have an issue, but the only proof I can see right there is probably going to the Social Security office, changing your name there, and going to the DMV and also change your name there, and then put those to proof. Hopefully they will accept both. Okay?
Perfect. Sounds good.
Okay.
Thank you.
Good luck to you. Let me take another caller. This is Shah Peerally here. Hello? 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 Hello, this is Shah Peerally here. Okay, I think I lost the caller, Michael. So feel free to call again, 510-657-1170, 510-657-1170. Just to let you know, we get all the calls at the same time, so please bear with me while I'm answering someone. You just have to hold on, and then I will take your call next. So please, I apologize for that, but that's how technology works in this system. So for those who want to call, feel free again to call the office if you want a private consultation. 510-742-5887. 510-742-5887. We were talking a little bit about 221G, which is the administrative processings, and when people travel outside, can they come back? And that has been an issue, by the way, for a lot of people. And then we have this other issue that, the prudential revocation. Prudential revocation are usually now, this has been there since Obama time, by the way. What the State Department has done, if someone get a DUI, for example, or some kind of criminal record, what they will do, they will go ahead and just revoke your visa and your passport. It doesn't block you from staying if you're already staying in the U.S., but when you travel back, you will have to go and get a new stamping. We'll talk about that in a minute. Let me take the next caller, Mike. This is Shah Peerally, you're live on air. Hello.
Hi, Shah. This is Parag here. Shah, I have a question for you. Yeah, I'm doing good. How about you? So, Shah, this question is regarding that the I-140. So, it has a three-part to it. The question is same. The first part, if the I-140 process is going on and someone gets promoted to a next role, how is that taken care of it? Or someone has to wait until the I-1 get approved and not to go for any promotion? Or the second thing is that, let's say the I-140 is approved, and after the approval of the I-140, someone gets promoted. How is that handled? Or does the person has to stay in the same role until the whole green card get approved within the same company? Or if person changes his job, move to the other company, can he take up a next level of the next job promotion Is it possible, or ideally the person has to stay in the same job role? And the job promotion which I'm talking about is all within the same category. For example, like from computer system analyst to IT project manager or IT program manager or something like that.
Okay. Let me answer one by one before I forget. You have 3 questions here, and they're awesome questions, by the way. I really thank you for asking that because I miss that all the time. So number 1, what happens is that since perm or the I-140 is for future employment, I repeat that, since it is for future employment, it doesn't matter if you're working in one role and you're filing under a different role. Okay? However, when the green card becomes ready in your hand, you're supposed to go back to that job. Okay? So, to answer your second question, if the I-140 is approved and you get a promotion, do you have to redo the I-140? The answer is no. However, as a common practice, the company will redo the I-140, basically redo the labor certification because they don't want to give you that job offer when the green card is available. However, nothing prevents them from bringing you back, downgrading you when the time to get the green card. Okay. Now the third question, you are in this job description, you're trying to move to another company on a different job description. The only thing you keep really when you move is your priority date, and that doesn't matter which job description it was obtained. For example, you can even have a priority date as a lawyer and file as an IT engineer. Not that extreme, but yeah, that's how it works. So the priority date is just a ticket in the line, right, in the queue. So you don't have to worry about that part. Now, as a piece of recommendation, I will recommend to you let that I-140 gets approved. Then you do any move after that. The reason for that is that you lock that I-140 priority date, number 1. Number 2, if in case you need an I-140 to do an extension on your H-1B, you can still use that same I-140, although it's a different job. Okay, so remember that rule. That means it's for future employment. So there's no need to shift at this point. However, down the road, ultimately you'll have to shift unless they're going to demote you when you get the green card. So you're following the logic here?
Yeah. So in that case, like let's say the part 2 which you were answering that after the I-140 is approved, the company as a precaution they can file the another I-140. So with that also
they can't file directly another I-140. They have to redo a labor certification, then refile an I-140. They cannot just file another I-140 just like that. No, they have to redo it from zero. But you will keep the priority date.
But in that also the priority date will remain intact? I mean, no change in the priority date?
The only time you will be able to maintain the priority date if you go in scenario 2 and 3. Number 1, you won't, because if you stop the I-140 at this point, right, you don't file it, you don't get it approved, you cannot claim that priority date on the next petition, even with company A or company B or company C. So the best for you is to continue on this one. Hopefully they continue if they agree. Then once they finish with that, you get your I-140 approved, because there's no rule that prevents you from getting demoted later if they need someone in that position. As long as it's a genuine job offer, they can still bring you back there. However, in the future, if they don't intend to do that, at least they can log that priority date. They do another labor certification, refile a new I-140, and use that priority date. And now the third option, if you're moving to another company, just be careful, because within 6 months they can always withdraw that I-140 and you won't be able to use it for H-1B extension, etc. However, once the I-140 is approved, even withdrawn, you still retain that priority date. So that priority date is important. In case 2 and 3, you can keep that priority date.
Okay. So in this case, another 2 and 3 are the recommended option. One is not a good or the safe route to go with.
It's not unsafe. Only problem is that you're losing a good chance of a priority date, because right now the process probably took almost 8 months or almost 1 year. That means you will lose 1 year for nothing.
Yeah.
Now if the company feels uncomfortable, they have no job offer in this position, then they have to stop. But if they think that they can still give you something down the road, let's say, for example, suddenly the priority date become current, and they can send you back to that position where they got your labor certification approved, then there's nothing wrong. The only time it becomes very wrong is if there's no possible job offer in that field. Getting a promotion doesn't mean that other job is not available, right? it's up to you. You can accept a promotion or don't accept it, right? So it all depends. However, yeah, go ahead.
Sorry, and the current H1 has nothing to do with it. I mean, many people do say that your current H1 also should be in line with the I-140, the designation of the
No, it doesn't have to. It doesn't have to. However, as a matter of fairness and a matter of being genuine, it is good to be aligned. But there's nothing. For example, let's say someone is a system analyst, an H1B, and then they get a computer manager job or computer engineering or something like that. They can have the I-140 on system analyst and the offer on computer engineer, something like that, right? So there's no bearing on one on the other. However, it becomes a problem if you're inconsistent. That becomes a different issue. So, for example, if on the H1B you put a bunch of a bunch of job description that you have done, and then when you do your labor, you put different ones, then there will be a mismatch. But otherwise, no, it doesn't prevent you from having a labor under one job description and an H1B on another.
Okay. Sounds good. Yes.
I hope I was able to be clear. But these are very good questions because I never had a chance to really cover this topic, and thank you for bringing it up. Okay. Good luck to you. Bye. If you need help, call me 510-742-5887. Okay. And we can discuss further and apply, because even I gave you the general rule, you might have small issues that can prevent what I just said. So you have to be careful. Okay. Okay.
Yep. Thank you so much.
Good luck to you. Good luck to you. So much, and feel free to call. The number to the studio today is 510-657-1170. This is Attorney Shah Peerally, and anything I'm telling you today again is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And since we were talking a little bit about the prudential revocation, it is just something very important, especially if whenever you have this kind of situation, they would probably send you to a medical test, etc., and they have a special surgeon there, and to check if because what they have been doing is basically they have pinned the DUI as a mental issue, and that's where they're going to do they have a test with a doctor, making sure that you're mentally fit to enter the U.S. So be careful. Usually when you get this prudential revocation, it becomes what we call you won't be able to travel. Even if you have a stamp on your passport, that stamp has been revoked. However, if you're inside the U.S. and you're not going outside, the USCIS doesn't revoke the DUI under the case of Leocal, I think, if I'm not mistaken. They cannot deport you, but they can block you down the road. So be careful if you have a situation like that. Let me take another caller, Michael. This is Shah Peerally. You're live. Hello? 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 I think I lost the call. I'm so sorry. So please call again. The number to the studio, 510-657-1170, 510-657-1170. These are live shows, so we always have glitches. This is normal, so please feel free to call back. And I really apologize whenever we miss your call. I'm always glad to hear my listeners interacting with me, because that gives me, like, just the caller asked this question. These are important topics, but sometimes it's very hard for me to remember those topics unless someone bring it up. So please call if you have any question. I think I have one caller. This is Shah Peerally. You're live. Hello? Hello?
Hi, Shah. Good morning.
Hi, good morning. How are you, sir?
Good. A quick question. I am on H1B from 10 years. I am in a product company. I have to go to, I am on extension and I have to go to stamping if I go out of the country. So I have to go to Canada. So is it a safe choice, or do I need to go to my home country, India?
Okay. You had a stamp before, right? You had a stamp on your passport before, right?
Sorry?
Hello? Is it your first stamping, or you had a stamping before?
Yeah, I'm here from 10 years.
Okay, no, but you had a stamp on your passport before, right? You got a stamp before.
Yes.
Hmm?
Yes. Yes.
Okay. Yeah, then you can go to Canada. It's okay. Because the rules work like that. If it is your first stamping and you didn't graduate from a school in the US or Canada, you have a right to go to Canada or another country for your stamping. And is it safe? Well, hard to tell, but it's usually many people like it because it's fast. But, of course, that doesn't mean it makes the case easier because the questions might be the same, but the waiting time usually is less. So, yeah, it is a good idea to actually kind of go to Canada if you want to go. It's not a bad idea.
Sure. Thanks a lot.
Okay. Good luck to you. Let me take another caller, Michael. This is Shah Peerally, 11 a.m. Hello? 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 Oh, I'm so sorry. I think we had another caller. We are having some little technical difficulties here, but bear with us a little bit. I think I don't know if it is the system or because we're doing both lines at the same time. So please call 510-657-1170, 510-657-1170, and I will be glad to answer your question as much as I can. And earlier the caller talked about those I-140s, and it's kind of very interesting how the I-140 works. I-140, once it's approved, you cannot really use that with a different company. However, you can use it with a company B for priority date, unless, one thing I failed to mention, unless the I-140 has been revoked by USCIS for fraud or misrepresentation. I repeat that. Because withdrawing by the company of the I-140 doesn't take away your priority date, okay? There was a case in BIA a long time ago which said that, but that case is not even a good case because BIA doesn't really have jurisdiction on that, and it was an unpublished case. So don't take that exception for the rule. The rule still you can maintain that priority date. So again, ladies and gentlemen, feel free to call if you have any questions on immigration. 510-657-1170, 510-657-1170. Michael, I don't know how much time we got, but I think we have some good time to take more callers right now. So I was talking, of course, about 221G prior to that, and now a lot of people call me and they get stuck. There are not many ways to really kind of unclog that. One of the ways is, of course, to contact your congressperson. They are very helpful, by the way. Or ultimately filing a writ of mandamus, which is very complicated because you're suing the government in federal court, and that can backfire too, so you have to be careful on that. Let me take another caller. I think, Michael, we have a caller. This is Shah Peerally, 11 a.m. Hello? Hello? Okay. Hello, this is Shah Peerally, 11 a.m.
Hi.
Hi.
Priya, and I have a question on citizenship. So we have 1 year left. We are on green card and 1 year left. So is it too late, or can we apply immediately?
No, you cannot apply if you have one. What do you mean 1 year left? 1 year left on your green card, or you have 1 year left to complete your 4 years?
1 year left to green card, 10 years.
Oh, okay. Yeah, no, you can file any time. Go ahead and file, actually. Instead of filing for an extension of the green card, you can file right now.
Okay, and my other question is, how much time it will take for it? Is 1 year enough to get?
Yeah, you should get something within 1 year. Most of the places, they are processing within, depending where you're located, it's processing between 8 months to 1 year. But if you don't see anything, you reach around 8 months, I would recommend filing an extension on file an I-90 on your green card to get the green card extended, because then that means the case is getting delayed. So 8 months to 9 months down the road, if you don't see anything, file for your extension. But don't file the extension right now and file the citizenship, because it will confuse the case. So go ahead, file your citizenship and see what happens. But within 8 months, they are processing cases, especially if you're in the Bay Area.
Okay, so for extension, it won't take much time as much as...
No, it does, because the problem what they are doing now, every case is reviewed from the beginning. So that means they have to go back in time and check how you got your green card, etc., and do an extensive background check. But it's taking around 6 months to 7 months to get renewal. Some people get it earlier. But for citizenship, because they are a little bit overwhelmed, it is taking almost 8 months to 1 year. Okay?
So is it legal once you, if citizenship is delayed and green card, we process the extension, that period, that overlapping period, is that legal?
Yes, it is legal, but it will be good if you file the extension on the green card. Then while it's pending, you are in a period of stay. And in fact, if you want to travel, as soon as you get the receipt, you go to the USCIS, ask them to put a stamp of I-551 on your passport, and that will even allow you to travel. Because just because a green card is expired doesn't mean you lost that position of a green card holder. All it is that the proof of being a green card holder is no longer in your hands. So if you file an extension before it expires, even 1 month before, and it's pending, you're fine. So if this happens, give me a call, then I'll guide you what to do, okay?
Oh, yeah, sure. And also one more question. So can we apply online ourselves, or do we have to go through some attorney or some third party?
You don't have to go. No, you don't have to go to an attorney. Applying online, the N400, I don't know if it's available. I don't apply online because I don't recommend it. Sometimes they have glitches in the system. The best is just to print the form N400, follow the instructions, and fill it online and then mail it. And if you need help on that too, we can help you. Give us a call, 510-7425-887. But you don't really need a lawyer to do it, okay?
Oh, but we can apply, take a printout and we can apply ourselves, right?
Of course, yes.
Yeah, sure. Thank you so much.
Good luck to you, good luck. Let me take a call. This is Shah Peerally, you're live on air. Hello? 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 I think I lost the caller again. I'm really sorry. So, ladies and gentlemen, I think we have the caller back. This is Shah Peerally, you're live on air. Okay. So, I think we're the call drop again. Feel free to call again. We have another 10 to 12 minutes. 510-657-1170. 510-657-1170. And we were talking a little bit about the issues related to, of course, prudential revocation, and also making sure that if you get stuck under 221G, what you can do. Well, unfortunately, there are not many options. Even you hire the best lawyers, they might not be able to unclog that. So the best is to contact your congressperson, which means a senator or a House representative member, or ultimately file a writ of mandamus, which is, like I said, it's a headache, and most lawyers don't like to file it. I used to file a lot of them. Even me now, I'm kind of reluctant to file it because it can carry it can backfire. Let me take another caller. This is Shah live on air. Hello? Hello? Yes, this is Shah. How are you?
Hi, this is Reena, and I'm actually calling with reference to parents' green card process.
Yes. I'm sorry, I couldn't hear you.
It's a birth certificate. And that's the reason I just wanted to check, because they were it was back then when they were not born in a proper city and the registration wasn't there. So in that case, we had provided a non-availability, but somehow we have got an RFP asking whether it needs to be submitted in a formal document. So that's kind of because it was
I'm kind of losing Veena. Veena, I'm not really hearing you a lot, but I kind of getting the idea. So you've provided a certificate of unavailability. Where did you get that? You're supposed to get it from the registrar office where you're supposed to register.
So basically we got it from the district office, which is the district office for that particular state. And that's how we have got it. It is through the gazetted officer. That's how the format is what we were told.
Okay, so are you sure? Double check on that, because if they're asking that, either they're making a mistake or they know something that you probably don't know. Because sometimes what happens, it's the local government that issues that, and people go to the general government. The general government still issues it, but what they are looking for is something from the local government proving no birth certificate was issued. So at this point in time, then, if you said there's nothing issued, you need to confirm that. The biggest problem we're having with India now, I think India is going electronic, and they're issuing what we call latent birth certificates. What it does, they issue a birth certificate at a later stage with the present date. And those are still secondary evidence. You still have to put affidavit, etc. So I need to see what exactly they're saying, because I cannot really answer on this part. Hello?
Okay. Okay, so maybe do you help out in situations like this?
I can. First I have to see. Why don't you do this? Give me a call at the office and email me the certificate at info@peerallylaw.com or shah@peerallylaw.com, and we can do a consultation and go over it. But usually the problem is that I'm not familiar with every state in India. You need to find someone there who is a little bit knowledgeable about that, and who can actually double check if the non-availability certificate you got came from the right authority. If they're questioning that, they might have, because what happens, the adjudicator, he has a list of places of origin of certificates. So if the places of origin is not matching on their database, they will tell you, oh, basically what you gave them is not the right one. So that's what probably has happened in your case, or they made a mistake. Because sometimes you will go to a government, they say, okay, this us who issues that. But right now it's them, but in the past it was not them. So you need to research that, okay?
Got it. Okay. Thank you.
Good luck to you. Okay, give me a call, 510-742-5887. We can do a personal consultation on this, okay?
Sure.
Good luck to
Thank you.
Take care. Bye-bye. So let me take a caller. This is Shah Peerally, you're live on air. Hello? Hello? Okay, I think we'll have the caller again. Feel free to call. I think we have another, 10 minutes, Michael? Or not less than that. 506571170. This is Shah Peerally, you're live on air.
Yeah, hi.
Hello?
Hi, Mr. Ali. First of all, thanks for doing the excellent job.
Oh, thank you so much.
Yeah, and secondly, I have a question. I'm on H1B, and my wife was on H1B earlier, but then she had to change it to H4 due to some circumstances. She got her EAD, and she has been working on H4 EAD from past 2 years. Now my H1B extension is lined up in November, and her employer is processing her H1 transfer as well. So she doesn't have to go to the CAPS. But my question here is, my extension is also in progress. Should I just hold off my extension, because I don't want her H4 to be extended? You know what I mean?
No, you don't have to hold off your H1. All you have to do is to make sure that no H4 is being filed for her. Just let them go ahead and file for H1 for her. But if you are not sure the H1 will be approved, because not for the reason of CAP exam, because she's CAP exempt, then it's good to have the H4 as a backup. Otherwise, just don't worry about it, because unless you file an H4 attached to the H1, it doesn't automatically extend the H4 for her. So you don't have to worry on that part. Just make sure that the lawyer knows that another H1 was filed for your wife, and there's a pending case, so no need to file an H4. That's all you have to do.
Oh, okay. So I just have to call that out right now, because right now itself the paperwork is going on, the LCA and all those stuff. I'm assuming that her H1 should be getting filed in next 1 month or maybe 2 tops. And same goes for me as well, that my paperwork is in progress, and I'm hoping that my extension would be filed in next coming 2-3 months.
Okay. Well, this is the thing. Unless you file an extension on H4, this is a good question you asked. The H4 extension doesn't happen automatically, okay? So in this case, since you're not interested in that, you don't do that. But make sure you have the lawyer do that for you, because what will happen is that by default, all the lawyers, just to avoid any kind of complication, they will go ahead and file the H4. So you need to make sure that you let them know, We're not filing an H4 because she has an H1B file, and send it in an email in writing. Otherwise, the lawyer can be responsible if they don't file the H4. So just as a matter of caution, most lawyers will file. So in this case, you need to make sure that you pretty much kind of cover this end. So as long as you do that, you should be fine. Then there's no need to do anything else about it, so don't stress on it. But just make sure they file her H1 and the H1 is in good shape, because if it is a kind of a weak H1, then it's good to have a backup. But bottom line, if you get your... I'm sorry?
Yeah, exactly. I mean, my follow-up question, I was about to that. But finish your thought first.
No, what I'm saying is that, let's say, for example, you don't file the H4 extension for her. H1 is filed and H1 is denied, God forbid, right? You can always bring her back on H4. H4 is easily to get. You just take your H1, you make her leave the country, apply for an H4, and come back. She will be back on H4.
Oh, okay. So you're saying that in case something goes wrong with H1, we will still have a H4 backup, and it can be filed after my H1 extension, not together.
Yes.
Is that right?
Exactly. You don't file it as an extension this time, because if she already passed her date, if it is before her date of H4 expiring, you can file it inside the US. If not, then she has to leave the country, get a stamp, come back, and her H4 will kick in based on your H1. Okay?
Yeah. The problem is her EAD is also stick with H4 date, right? So if something goes wrong with
EAD,
H1...
you will have to refile the EAD. Then the whole question will revolve how strong is her H1. Not her cap exemption, because she's cap exempt. The strength of her H1 will depend how strong is the company, the job offer, specialty occupation, etc. If that's strong, that's fine. However, what they should do, file it under premium. She still have some month left on her H4, so you will know within 2-3 weeks. And if something is wrong, just quickly file her H4 extension and EAD extension. Okay? And call me if there's any problem, then I can guide you, because right now in 2 minutes is kind of hard, but
absolutely,
just make sure you follow the plan.
I'll touch base with you offline after that.
Okay, thank you so much. I really appreciate it, and thank you for your kind words. So, ladies and gentlemen, I think I have 5 more minutes to go. I don't think I'll be able to take more callers now, Michael. Feel free to call our office, 510-742-5887. I'm going to talk a little bit about debt settlement. This is another area of law where we have people. And again, sometimes people get confused with debt settlement and debt consolidation. We don't do debt consolidation. The difference with debt consolidation is that debt consolidation is when they kind of take all your debts, put it in one basket, and make a payment plan. Oftentimes, that doesn't work. The reason for that is that most people don't follow through, and you end up by paying the same or probably more. What we do here, we negotiate those loans at a lower price, kind of, and try to get you a deal. And as long as we are able to do that, we can actually kind of end up by getting you something better than many times. For example, you owe $10,000 on a credit card, we can get you less than the $10,000, and you end up by paying only that, and you're out of the debt. And that doesn't mean it works for everybody, and that's why we work on contingency when it comes to those cases. So I just wanted to know how much time we have left, Michael, and I'm going to kind of close today for the show. And we talk about some very, very good points today, including I-140s, family petitions, and thank you so much for calling, because it gives me momentum to cover different topics which I don't think of. So feel free to keep checking our website, attorneyonair.com, and our YouTube channel, youtube.com/Shah Peerally Law Show, Shah Peerally Law Show. And please like it and subscribe to it. I try to put updates as much as possible in there. And thank you, Michael. And anything I told you today is educational in nature. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Again, the number to our office, 510-742-5887. Thank you. Take care. We'll be back next week. Amit, are you there?
Hey, sir. How are you?
I'm doing well, Amit. I'm doing well. I'll let you finish. Thank you, Michael. Take care. Bye-bye.
Thank you, Shah, and thank you for having me, and hello to all the listeners. Sat Sri Akal,